As a part of predicting the future, certain academics view the current globalization and the interdependence of national legal systems to lead to a uniform legal system applicable across borders. Now, that is extremely hard to envisage. If you think about it, how can a legal system exist that encompasses both the principles of common law Australia and Sharia law Afghanistan? The reality is that morals, justice, and what's right and wrong are subjective concepts that vary all across the world. There are clearly difficulties in whether this is possible. However, a strategy has been proposed called legal pluralism. Hi, my name is Sikandar Zaman, and today I will be talking to you about legal pluralism. Now, legal pluralism, what even is it? Essentially, it's a concept, and because it's a concept, there are a few different broad and narrow definitions. John Griffith, in his article from 1986, defined legal pluralism as justified as a technique of governance on pragmatic grounds. Sean Larcombe and multiple other academics primarily draw from the work of William Twining and define legal pluralism as a situation where at least two legal orders assert jurisdiction over the same geographical space and persons within that space. Now, a legal order is something I'll be mentioning quite a lot and is defined as a set of rules and practices that are orientated towards ordering relations between persons with its own source of authority. Now, for example, different kinds of human ideals, religions, ethics, business, and arts can bring about different legal orders. That's a lot of words, but essentially, legal pluralism is the theory of multiple legal systems existing in the one human population. Traditionally, it has been used in colonial law, where certain issues will be covered by one legal system and the other issues will be covered by another. To a certain extent, you can see legal pluralism being implemented in the modern day world as well. Most prominently, you see it in Islamic courts. In countries that implement some form of Islamic law, Muslim communities resolve certain issues following Islamic law principles, and other issues are dealt with secular courts. Other examples include the Mabo decision giving recognition to Aboriginal law, and certain customary laws which are recognized alongside the traditional state laws. After a brief understanding of legal pluralism, the idea behind it is undeniably interesting. But why legal pluralism? The current global legal landscape is not full of neat and distinct legal systems that are state-run. Currently, the municipal state law and international law are not the only fields. As William Twining states, accepting that non-state law in the form of religious and customary law exists leads to recognizing that legal pluralism exists as well. In a thought piece about the future, Benjamin Adoki, the Chief Justice of the Supreme Court of Uganda, identified the trend of legal pluralism emerging in the near future. He believed that in the future, with the lack of resources and the disadvantages of having a divided international community, the states will look to consolidate resources and economies in a common legal system. And in actuality, even now, low-level regional integration is seen in Africa. States are coming together to form stronger regional blocs with more international power. Now, from a practical standpoint, there are a few problems that jump out at us. Obviously, it leads to the question of how can the legal order, let's say for example Sharia law, coexist with the common law jurisdiction of Australia? I personally feel that the main issues in this theory is the clash between state law and non-state religious law. The fact is that although it exists, legal pluralism incorporates non-state legal orders alongside state legal orders. These non-state legal orders are a lot of the time oppressive, unjust, inefficient, and incompatible with the ideal of the rule of law. On the other hand, however, it's extremely difficult to bring a religious group of people into a system that doesn't support the religious or customary norms. This friction between religion and the state will only increase in the future, especially in the field of gender and sexuality. The issues entailed with legal pluralism have been broken down into three main categories in the Journal of Legal Pluralism. Firstly, where avoiding wrong behavior under one legal order leads to wrong behavior in the other. This is called rivalrous compliance. Essentially, the person has to choose which legal order to commit the wrong under. Some examples are Sikhs carrying a kirpan, which is a sword under their 5 articles, versus a prohibition in carrying knives by the state. Another example is the confidentiality of confession in church versus the divulging of conversations under oath. This is an issue for legal orders because regardless of what a person does, a wrong will be done. A solution for this issue requires one legal order to reform itself or provide an exception for those individuals placed in such a circumstance. In some cases, we see state agents unwilling to prosecute when the individual has been left in this rock in a hard place dilemma. An example is acts allowing the Sikhs exemption to wear turbans and carry swords for religious purposes. The second issue is where sanctions of one legal order are considered wrong by the other legal order. For example, punishment of idiosyncratic wrongs. If the wrong is idiosyncratic to the non-state legal order, the state can sanction it itself. A solution could be for a state to exempt or provide defenses for such sanctions that would normally be considered wrong. For example, lenient sentencing practices by the colonial courts of Papua New Guinea for those who were convicted of a homicide but motivated by customary considerations. The final issue is the uncoordinated sanctioning of common wrongs. This occurs when the legal orders fail to coordinate the enforcement of sanctions in terms of total magnitude of sanction. So legal orders are ignoring the other sanction for the same wrong. So essentially it's excessive punishment. This wrong will be more common when non-state sanctions are of high magnitude. This results in situations where even if two legal orders are concerned with the sanctioning the same wrong, it can result in a net fall in deterrence for common wrongs. Some solutions for this issue are that if a state is able to quickly signal that it will sanction a wrongdoer, it should reduce the propensity of a high magnitude non-state sanction being enforced. Alternatively, and controversially, a state could recognize the non-state sanction as a valid substitute. For example, in Pakistan, the state recognizes the payment of a diya to wholly substitute for a death sentence or imprisonment. This is what I personally feel that legal pluralism is trying to achieve too much. The fact is that for certain legal orders, there are no middle grounds. In certain cases, such as the Sikhs with their turbans or the state recognizing certain aspects of Aboriginal law, I feel that the application of legal pluralism is effective in promoting coexistence and cooperation. However, I feel that in all cases, non-state law such as customary and religious law should always be secondary to state law created by Parliament through a democratic process. For example, in Pakistan, the concept of monetary payment instead of a death penalty is in my mind unacceptable, and a state recognizing that form of sanction as a substitute is completely wrong. Increasingly, in the present-day world, religion has been used as a weapon in class conflicts and used for far less pure things than it was intended for. I feel that these non-state laws, such as religious laws, are highly personal concepts, and although important to society, they should only be allowed insofar as any inconsistencies with the statutory state law. Even now, these non-state laws are being perceived as archaic and slowly being sidelined. Perhaps in the future they will continue to be phased out and ultimately result in the integration of legal systems, resulting in the regional law that is applicable to everyone. Now, although legal pluralism is a complicated legal theory, I hope that this video has provided some food for thought and something to think about for the future. I thank you for your time.